Blood, Sweat and Tears out of 1969. That's okay, Rob. Rob's just run back into the studio puffing because he had to go outside and take a phone call. It is 6 minutes past 10 o'clock on a Saturday morning. You're listening to the Two Blokes Chatting radio show. And, Rob, you may wonder why I played a song called And When I Die.
Oh, that's a bit morbid, but it makes sense with what we're going to talk about.
I just figured it was the right thing to do. On the line we have from Wightons Lawyers. They're on the corner of Gap, Moorabool. Which one? Moorabool and Myers. They are local lawyers. We have got Jesse Rankine. Now, Jesse is an expert in wills and estates and plenty of other things, but specifically that because during the week, I got my will done for the first time, and I thought to myself, we probably should talk a bit about this. Hello, Jesse.
Hello. How you going?
Good, thanks, mate. This is Neil. The other voice you'll hear, the sort of warm, sexy, husky voice is Rob.
Good morning, Jesse, and thank you very much for your time on what is an important issue, and ironically, in my own personal life, it's something that I've been talking about recently. So when Neil suggested, I thought, oh, you beauty, I might learn something myself.
Yeah, sounds good.
Now, we should just stress up front, I guess, that anything that we talk about today is very general in terms of what we are talking about, so don't take it as gospel. Jesse knows what he's talking about. Clearly, as people who listen to this program know, Rob and I know very little about much. So you would be very sensible to get your own legal advice coming off the back of this. But we thought it was important to talk about, well, for starters, what's a will?
A will.
That's a good starting point.
Document that expresses what you wish to happen with your assets most after you die, and also the appointment of who's going to be carrying out those wishes, which is the appointment of your executor. They're probably the most important two aspects of a will, but it can cover other aspects such as funeral wishes and who's controlling your family trust or things like that can go in a will also.
So clearly, because Rob and I are both just rolling in it, not. So obviously things like family homes and finances and heirlooms and all that sort of stuff go in there. But can it be quite as specific as, and by the way, the signed copy of Jokers and Queens by John English and Marcia Hines goes to Rob? Can it be that specific?
Absolutely, yeah. People put specific items in their wills all the time. Particularly, most commonly jewellery. I give my wedding ring or my engagement ring to my daughter is a very, very common specific gift that we put in wills.
The distribution of that can get quite messy in families that may be broken situations or maybe siblings not getting along so well. And one of the issues that I've had discussions about is how concrete a will actually is. When you've got someone's wishes being allayed in the will that can still yet be challenged later on, that is a concern for me about the need to go and seek professional advice rather than just grabbing a will kit and throwing something together, which is your intent but not necessarily legal.
Yeah, it can be an issue. It's probably not an issue in 80% of cases, but yeah, there's probably 10 to 20% where people want to sort of deviate from what I call the norm, leave everything to the wife or the kids or, the sort of the standard arrangement. But if you want to deviate from that, you need to be very, very careful about how you do it. So there are means and ways of doing it better than others. If there's specific reasons why you want to deviate from that, like for example, if you've got a son, you've made substantial advances to that son, and you haven't given the same level of advances to the other children, maybe it's fit and proper that you benefit those other children more. And it's very important to write those reasons down in the will, so long as they're valid reasons and not, I don't like him, he's a jerk.
Yeah, well, that's the thing.
Hang on a minute, I'm just going to change mine back now, will I?
That's the issue that seems that there are certainly been high-profile cases of a parent saying that they don't like one particular child more than the other doesn't necessarily hold up in a court of law later on if that one of the children wishes to challenge the will, saying, well, hang on, I'm one of the children, I deserve to be equally compensated. That's
right, and particularly if that child is not in a great financial position, it's probably one of the key aspects that the court would consider. Obviously, if that child is a multimillionaire, they've got, very little chance of succeeding in that kind of claim. But if they're don't own their home and don't necessarily have a high-paying job and don't have prospects of earning a lot of money, and the other children are all doing well then the law does recognise those aspects.
Just an opportunity to give your the legal fraternity a bit of a plug here, understanding that. But for some people, and I can tell you without fear of contradiction, some people do not go to legal professionals to do their wills because they simply can't afford it. So they go on and get a legal will kit, but then it has to be held somewhere. It has to be someone responsible for it. But in all seriousness, I'm getting more and more along the lines of thinking that the extra investment, even if you have to maybe borrow the money to get a will done, the investment in getting it done professionally is probably going to pay dividends down the track. Would that be a fair assumption?
Yeah, absolutely. I appreciate everyone's financial position is different, but we at Wightons believe that it's not very expensive. Like probably $1,000 would set you up with a pretty good will and all of the powers of attorney. And that's it's $1,000. Yes, I appreciate that is a lot of money, and not everyone, has the ability to just, pay that. But for the peace of mind in knowing that it's been done properly and the wishes are going to be carried out correctly, and the will is going to be stored at a professional level in a proper strong room that is safe from prying eyes and burning down and all of those kind of issues, we believe it's a solid investment.
Well, particularly given in a significant proportion of wills, I would have thought, there would be one or two significant assets to be written into it, such as a family home or maybe an investment property or someone's superannuation. And when you compare to that, as you say, it's yes, $1,000 is a lot of money, and in fact mine cost $990. So there you go. I'm happy to announce that during the week.
Yeah.
But it's an investment. It's not a cost, if is what I think I'm saying.
Yeah, absolutely. And there is very much a hidden cost in doing it cheaply or by yourself, or using a will kit or online with these AI-generated documents that don't necessarily take into account what the law is in Victoria. There is a risk. So I've seen plenty of wills over the years that have been done, in a will kit, for example, and there's an ambiguity in the will. And what actually happens is we end up having to go to court after the person passes away to address what that ambiguity means. And we end up spending, $30,000 or $40,000 on addressing the ambiguity for the sake of, saving, not a lot of money now.
Yeah, so 30,000 is more than 1,000, I think, the last time I did my mathematics teaching in the mid-1800s.
Yeah.
The other thing that causes problems from my own experience, is multiple wills, wills that maybe been done at a different stage of life and then they've changed because of certain circumstances, and upon the passing, the wills all come out. Is there a clear understanding in the state of Victoria or elsewhere that one will written is immediately superseded by the second one written and signed, or can it be, if someone feels aggrieved, they can go back to will number one because they did better in it?
Uh-huh. Yeah, the vast majority of the time it's very clear that it's, the last will is the will, and almost every single will you'll see, the first paragraph will say, I revoke all previous wills. So that is, it's most of the time it is the last will that counts. However, if there's any argument about the validity of that will, for example, I might have an elderly client, they might have some cognitive decline. Now, just because someone is older or suffering from some level of cognitive decline does not necessarily mean they're automatically unable to make a will. There's a very specific test that has to be administered to the client, and so long as they can satisfy all the limbs of that test, they're entitled to make the will. However, it can be a bit of a grey area. You can have conflicting doctors having conflicting reports about the level of incapacity of the client. You can have different lawyers having different perspectives on the level of incapacity of the client, because the client is going to perform differently in different circumstances and at different times. And so in that situation, it's very, very messy. And yeah, it's one of the it's not a good situation when you're in court arguing about which will goes up and which is not valid.
I would have thought also, I've got to be very delicate how I ask this question or state this observation. There are chaps and ladies, I guess, but in my circle, chaps who are, let's call them in their 70s or 80s, and they find themselves widowed. And to get them through the rest of their life, they find someone who's 35 and, maybe thinks that they're... gold digger is a word that's running around the back of my head at the moment.
It can happen the opposite way around.
Yeah,
too,
that's
now.
what I said. But in my circle, they've all been blokes. That, I suspect, is where you don't want your will kit. It's where you want someone who knows what they're talking about, helping you to prepare so that whatever the correct outcome is, whether that person is the correct beneficiary or, in fact, they've come along at the right time to take advantage, having the legal component to it would be critical, I would have thought.
Absolutely. And
I think we got that okay.
Sometimes it is tricky in those kind of situations. and you've got to really balance up, what's the obligation to the kids, what's the obligation to the new partner, because from the client's perspective, that's the new partner. It's not a gold digger to the client. It's this is my new partner, and so we've got to establish a plan that takes into account the levels of provision that needs to go to both of them. And so it might be that you set up a life interest trust or something like that to the gold digger, so to speak.
Yes, I'm retracting that and calling them an alleged gold digger.
Alleged gold digger.
Yeah, that's probably better.
Yeah, but then a life interest trust is going to go for many, many years because of the life interest. So that and sometimes that may not be practicable. So we might have to think of other ways, like splitting up assets and what's fair and reasonable, and making sure maybe the partner gets the house and the children gets the superannuation, for example, might be a good way because there's some special rules around superannuation nominations, and you can make a binding nomination that can't be contested. So that might be a good way to make sure that the children are still getting some level of provision.
We're talking to Jesse Rankine from Wightons Lawyers about wills and estates. Now, one of the things that was put on the table in front of me, metaphorically, you understand, it physically wasn't, but we talked about it, was the concept of a power of attorney, and in fact two types of power of attorney, one relating to my health and one relating to my financial circus pants. What's a power of attorney?
Sure.
Sorry, I know what one is, but I'm using that as a question to...
no worries. Thank you.
Yeah.
A power of attorney is effectively a document that authorises someone to be able to sign on your behalf and make decisions on your behalf. It's particularly useful if something happens to you where you lose capacity, and that's the whole crux of it. So the idea is you have a stroke, you're in hospital. It's not like you can talk to the doctor and give consent to medical treatment happening to you. The doctor is going to have to speak to someone else. So this is a written authority that authorises, a partner or a child or someone else, a trusted person, to be able to communicate with the doctor about what it is that you would want and whether or not you want that medical treatment. Now that's the medical side of things. In addition, while you're in hospital, someone may need to access your bank account. They may need to pay your bills or deal with Centrelink or Medicare, tax office, that kind of thing, which is your financial affairs. And so that's what we call a financial power of attorney. Now, in addition, there is actually a third layer here. There is something called a personal power of attorney, and a personal power of attorney makes a decision about where you live in the event that you cannot return home. So if you don't recover from the stroke or whatever has put you in hospital, it may be necessary to change your living arrangements into some sort of care accommodation. That's a personal decision, and it's a third one that's often overlooked, but I think it's really important.
If people are able to afford a will and all the trimmings, they can take the right steps. I think the important thing about this sort of conversation is to remind some people that even though things are going along swimmingly well at the moment, it is something you really need to have a serious conversation with your family, certainly your spouse at least, and even if you're find yourself on your own now and you might have children, it's probably time to get it done. But you mentioned before about the simplistic version for those that are are thinking, well, I probably should do it, but I can't afford it. Really, for that investment of $1,000, what's the simplistic requirement of them to visit you or someone in the legal fraternity, and how much time would it take, and what would they need to bring to the conversation?
Sure. So, in terms of simplistic, I don't think it's reasonable to assume that you're going to be getting, for $1,000, a testamentary trust or, a right to reside, or some of those more complicated, more specialist clauses in your will. For something like that, you might have to pay a little bit extra. It's not going to be huge, but maybe just be aware of that. But in terms of what you need for the appointment, it's just an understanding of who your beneficiaries, who are your family members, who do you have obligations to make provision for, what are your assets and liabilities. So it's really important that you be able to articulate to the lawyer what the estate consists of. So we need to get an understanding about, what shares you have, what investments you have, where do you have your bank account, whether these assets are jointly held with a partner or whether they're individually held in your own name. This initial conversation, we allow up to 1 hour or around an hour for that initial conversation. After that initial appointment, we usually prepare a draft will, which is usually sent about a week after the appointment. And the idea is that will is pretty close to the final version. Now, there might be the odd spelling mistake or something like that has crept through, and that's why we send it out in draft, so that the clients can see it in advance, make sure that they're happy with the product that they're receiving, and once they're happy, they come in for the second appointment to sign the will.
And stating the bleeding obvious, when that draft comes through, don't assume that it's correct. Go and pour yourself a glass of something, a glass of Shiraz or something, and work your way through it meticulously, because I think there's an expression legally binding stuck in there somewhere as well.
Yeah, well, that's right. Yeah, absolutely. I can't. That's a really fantastic point. Please do read the draft. Lawyers are often correct, but sometimes, mistakes are made. We're only human at the end of the day. So, although we hope that is, less than 1% of the time, it's very important that you read the draft will and make sure that it conforms with what you want. Now, the good thing is, particularly at my firm, when you come back in to sign, I will run through it with you again at the signing appointment to make sure that it really does coincide with what you want, both from the legal perspective, from my interpretation, to make sure that my interpretation of the will is aligned with the client's. So there is another layer of protection there, but yeah, absolutely, do read the will.
And the other confusion that I have heard stories of course, is the complication that government comes into play with their rules and regulations, so the winding up of estates can be quite difficult at times, and I've just wondered whether it could be a lot more simple for, say, someone who has 3 children and wants a simple division of everything I own, liquidate the lot, put it in a pot, they get a third each. It sounds very simple for us, but sometimes because of state regulations and the way maybe accounts are set up and property is owned, it does cause a few problems and can take some time.
It can, yeah. So we have to often go through the probate process, which is a court application to the Supreme Court of Victoria to prove the will, the validity of the will, before you can start selling property and closing substantial accounts. That is often required prior to that, and so yeah, the rule of thumb is that the idea is that most people would finalise a will within 12 months. Now, sometimes it's quicker than that. Sometimes it's a bit longer than that. If it's complicated, it can take many years. Sometimes in the 1% of situations, but for the vast majority of time, allow 12 months for the distribution of an estate.
Well, Jesse, it's been really, really helpful hearing all of this. I probably should have heard this some time ago, and I would have got off my you-know-what and done something about it. As I mentioned to you off air, I'm in my early 60s. Rob's well and truly into his late 40s now. Is there an age at which you would say, well, I have a 5-year-old grandson, probably not worth getting one done for him at the minute, but is there a legal minimum age, and is there a recommended age that this should take place?
Sure. The legal age is 18, so otherwise, if you want to make a will prior to 18, you would need court approval.
Mm-hmm.
This is for army and special circumstances. Otherwise, the recommended age is when you start either having substantial assets, so once you buy a house, or when you start having dependents. So once you have a partner or children, then this is the time when you need to come in and do your initial will. And then, you probably want to revise that will maybe 10, 15, 20 years later. Once the children are adults, for example, you probably want to do a second round on the estate planning front. And your financial situation would have changed drastically within that 20-year period as well. I
guess also another time for review would be when you go from having one child to two, for example, making sure that number two gets a mention. If I see a 30-year-old couple that have come in and they've got one child, one of the questions I'm asking them is, are you planning on having any more children? Because if you are, I'm not going to close off the class. I'm not going to say, I leave it to each other and then to this one child. I'll say I'll leave it to each other firstly and to any of our children as at the date of my death and attain the age of 21 years or something like that. Yeah.
So you keep it as an open class to reduce the need to come in and to update your will every time you have another child.
Because Rob doesn't refer to them as children; he calls them as heirs.
The heirs, that's right. Jesse, just a quick one on something that I'm hearing is a little more common, and that's gifting prior to your departure to ease the burden maybe on the will. Is that a part of that conversation as well, that if you've got plenty of assets, you've got more than you need for your own well-being till the termination of your life, to start to say, well, righto, kids, there's some stuff there, you might as well have it now. Can that be done during that conversation as well without penalty from state taxes and federal taxes and the like?
Yeah, so yes and no. Can I give a political...
I was going to say seek your own legal advice was my response to that.
So, definitely get legal advice to your specific situation. But generally... there are limits on how much you can gift if you are receiving Centrelink. So Centrelink obviously doesn't want to be, paying out money to people that they don't have to be. So, they don't want people, who have millions all of a sudden giving out to the kids and then turning around and saying, hey, Centrelink, I don't have any assets.
I don't have a job.
Yeah, I'm with you.
Yeah.
Okay, so that's a conversation that still can be had at that process to see what can take place. Because I think, that we've heard lots of conversations now about the bank of mum and dad getting children into their first home where they otherwise wouldn't be able to. That's now becoming something that more and more people are thinking about doing.
I hope my kids aren't listening.
If you've got cash assets and you're not reliant on Centrelink, that's fairly easy to organise gifting. If it's real estate, it's a little bit more tricky because you have to pay stamp duty in order to do a transfer of a house. So.
Yeah, no, that's fine. Understandable, but worth having the conversation. And again, you can't do that with a legal will kit. So if you've got the financial comfort, please go and do this, because it will save those close to you and those you care about a lot of grief. If you part quickly and you don't have a will, my goodness gracious me, things can get messy.
And it's funny, I feel so much better knowing I've done it. It's a bit like going to see the doctor and getting the annual checkup. You think, sure, that's good. I feel better now. Jesse, it's been great having a chat, and we appreciate you giving up some of your time, and I'm assuming we'll get an invoice for this because that's what lawyers do. No, that's not fair. Wightons Lawyers, Wightons Lawyers. You can find them at www.wightons.com.au, or if you're in town, you can wander up and say good day to the reception, I guess, on the corner of Moorabool and Myers Street here in Geelong. And you've got other places as well, haven't you, down Winchelsea or something?
Yeah, we've got an office in Corio and Ocean Grove.
Yeah, so thank you so much for generously giving up some time. It's a really important topic, and I'm so glad we've been able to have that chat.
No worries.
Thanks, Jesse. Best wishes.
Go on, you mate, Jesse there, Jesse Rankine from Wightons. Get your will kit, get your will done, and don't get a will kit would be my suggestion.
Yeah, I think so. I know it's difficult for some, but if you've got anything tucked away, and I know there's a lot of people maybe that own a house but don't have too much cash to spare, and that's getting stretched even more at this stage, but that house is an important part of your future for your children or those others close to you. The investment in getting it done properly is really worth it, it would seem. So please do that.
And talk, if you're not, there are plenty of legal firms. Being on community radio, we can't, recommend the one we're just talking to because they're not a sponsor, but it was really important that we found someone local who could talk about. But if you're thinking, I don't even know where to start, ask your next door neighbour, ask your friend, ask your uncle, ask anyone around you. Did they get their will done and who did it, and do you trust them, you know what I mean? As in, do you recommend them?